House Committee on Commerce and Economic Development. It is Friday, April 5th, 2024 at 1:07 in the afternoon. We're returning back from lunch and now turning our attentions to S-289, which is an act relating to age-appropriate design code. I think the first presenter, Zaman, good afternoon. Thank you for joining us.
Good afternoon. Can you hear me?
Yes, we can.
Great. All right, I can get started whenever.
Yes, sir.
Okay. Chair Marquardt, Vice Chair Jerome, and members of the Commerce and Economic Development Committee, thank you for inviting me to express my support for the Vermont Kids Code ahead of the opposition you will hear today. My name is Zaman Qureshi, and I'm a senior at American University in Washington, D.C., and I'm from Illinois. I'm the co-chair of Design It For Us, a coalition of youth activists from across the country driving state and federal policy to protect kids and teens online. I join you all today to share my own experience and to speak on behalf of my peers and coalition members. I co-founded our coalition in March 2023, but we have already made an impact. In 2022, the then Design It For Us campaign successfully advocated for the California Age-Appropriate Design Code, which passed the California State Legislature unanimously and was signed into law. This year, Design It For Us has supported the introduction of the Kids Code in Maryland, Minnesota, Vermont, Illinois, and others. And we have supported a trio of federal bills in Congress dedicated to holding social media giants accountable. The Vermont Kids Code is the first step to holding big tech accountable. Under the code, companies must set all defaults to the strictest privacy settings, design products for the safest experience for kids, stop tracking kids without notice, stop using kids' data to target detrimental material to them, and provide privacy tools for kids to take agency over their digital experience. These compliance measures put the onus on big tech, not on kids or their parents, to do what these companies should have done years ago and design their products for us. The young activists and advocates I represent have been advocating across the country over the past year to encourage lawmakers to adopt reforms like the Kids Code that implement safety by design and privacy by default guidelines for big tech companies to follow. These are young people who have taken time out of their school days, flown to Congress, testified before their state legislature, held rallies, and much more, all because social media platforms like Instagram, Snapchat, TikTok, YouTube, and others have failed to self-regulate. They failed to convince us that their products are safe. We are all too familiar with the harms of these platforms. It's an unfortunate reality that we and our peers are hooked on platforms we don't have the tools to get off of. And worse, some of our peers have experienced the gravest harms, whether it's the development of depression, anxiety, eating disorders, or worse, suicide. Today, you will hear from industry trade groups, paid for and fully funded by big tech, who will say that this bill is well-intentioned, but presents challenges. In our experience, these trade organizations are not engaging to improve the bill or seek input for a successful passage. They are here to stop its progress. I implore you to reject their talking points and instead listen to the voices of young people who have been harmed by these platforms as you advance the Kids Code. Before you listen to their testimony, I'd like to take some time to address what you will hear from them today. Big tech will say that this is going to break the internet, that the bill requirements are unclear and they simply cannot comply. But these are fear-mongering tactics. This kind of tech reform is currently law in the United Kingdom, and the internet is not broken. In fact, a recent report by Children and Screens highlights nearly 100 changes implemented by YouTube, TikTok, Snapchat, Instagram, Amazon Marketplace, and Google Search in order to adhere to the standards created by the UK's Age-Appropriate Design Code. And I'm happy to pass along this report to the committee if you have not already seen it. Big tech will say that the Kids Code violates parental rights because parents want to take responsibility for themselves. In reality, parents and kids are begging for help, supporting young people online beyond settings that platforms insist are already protecting us. A Washington Post report claimed that by the end of 2022, fewer than 10% of teens on Meta's Instagram enabled the parental supervision setting. And in recent responses for the record by Snap and Discord to the Senate Judiciary Committee show that fewer than 1% of parents use its parental tools. And finally, a recent poll reports that 87% of the electorate believes that it is important for the government to take action to combat the harms being caused by social media platforms. We know that parents need and want safer tech products to protect kids. This is not a replacement for parental responsibility, but a digital seatbelt supporting responsible parenting in the digital age. Big tech will say that this bill violates the First Amendment, as shown in the California AEDC lawsuit brought by NetChoice, a tech industry group. The Vermont Kids Code upholds free speech by focusing on platform designs and algorithms, not content removal, to mitigate harms, steering clear of regulating speech. There is no content moderation regime established in this bill. Opponents of this bill are trying to conflate regulating data privacy and design with speech and content moderation, intentionally creating confusion and alarm. But the Vermont Kids Code specifically regulates data management practices and product design. It does not regulate protected speech under the First Amendment because it does not target content or require tech companies to moderate content differently. It is not content-based regulation. Ultimately, we believe that big tech must be responsible for its products, like its algorithms and addictive features, and the Kids Code does just that. Big tech will say that this bill is going to be worse for privacy and that it will require mandatory facial recognition, ID checks, or other age verification. It will try to convince you that it is more privacy invasive. That is simply false. The bill does not mandate any form of age or identity verification. Companies already make age approximations of users based on the data that they collect. Big tech will try to convince you that this bill is going to be harmful to LGBTQ+ and minority children. They're trying to stoke fear based on false information. This bill allows children of all identities to safely access age-appropriate information and essential resources. The bill includes explicit anti-discrimination language that expressly prohibits tech companies from making any design choice that discriminates against a child based on race, religion, national origin, disability, gender, and/or sexual orientation. The Kids Code's strong privacy protections are important for LGBTQ+ youth who receive more frequent recommendations to friend or follow strangers on social media. Stronger default privacy settings and better data protection fosters an online environment for everyone to safely grow, explore, and express themselves. The LGBTQ+ youth I know and speak to want more protections on social media, especially as they are all too familiar with its harms. One of the first places for LGBTQ+ youth to explore their identity and sexuality is online, especially in restrictive communities. But without proper safeguards, we leave my peers open to frightening harms like financial sextortion. Big tech will try to persuade you that this bill is going to harm innovation and business. But in reality, we know that smart regulation spurs innovation by incentivizing companies to proactively address risks and develop safer, more ethical products from the outset. Big tech will point you towards other piecemeal solutions that fail to target its business model, instead suggesting that classrooms should better educate younger users on online harms and that law enforcement should play a greater role. While I agree that improving discussion in schools around these issues is necessary, teachers and schools have no power to turn off addictive features and harmful algorithms by default. Finally, when I testified before the Vermont Senate last month, one tech lobbyist suggested that the best way to keep kids safe online is parents taking away the phone from the child. All the meanwhile, NetChoice is fighting laws in states like Florida and Utah that restrict or ban access to social media for minors. While Design It For Us opposes all these approaches, it is abundantly clear that these organizations cannot be trusted to advocate for the safety of my peers. They're simply doing big tech's bidding and attempting to prevent any legislation from passing across the country that regulates its member companies. The Kids Code provides the safety mechanisms that young people are crying out for, and Vermont should pass this bill and sign this into law. I hope you'll find my perspective to be helpful as you listen to the next round of testimony today. I look forward to answering any of your questions and discussing this further. Thank you for having me.
Thank you. Questions? Yeah.
Good afternoon. Thank you for joining us and being a witness. I'd like to ask you a frank question with respect to these platforms that you've identified. And I know it's just, it'll be your opinion, but what do you think is a fundamental motivator for these platforms?
I think the fundamental motivator for these platforms is engagement, which turns into profit. More eyeballs on the screen leads to more profit because these platforms can serve younger users more ads. It's in their incentive to create business models that keep young people scrolling through nudges and addictive features. And as a result, really cast aside our mental health.
Thank you for your testimony. These companies that are already collecting a great deal of data about us, or their users rather, including they claim they cannot discern which users are under 18. Can you refute this claim?
Yeah, I mean, big tech companies, as we've discussed, collect endless amounts of data and information to target us with ads. It's the reason why I get different ads than you do, and the ads that I receive are different from some of my peers as well. So we know that big tech can make age estimations on the platform. The Kids Code allows for that kind of approach to this legislation rather than imposing some kind of age verification or facial recognition features.
I just want to say thank you. I can't stress enough how important it is to come from your age group, the age group that was inundated by tech as you're in your formative years. My kids are similar aged, and while we were sitting here, I sent your website to one of my kids, and she is very excited to know that you exist and is really excited about the work that you're doing. So truly appreciate that you're jumping in and trying to make a difference in this realm.
I appreciate that. Thank you.
Question? John, Jerry?
Close enough. So quick question. Now, you regard social media as platforms, not publishers, correct?
Yes.
Okay. I just wanted to double check regarding that.
Yes. Thank you very much.
Thank you. Thanks for having me.
Thank you.
Amy? Good afternoon.
Hi, good afternoon, members of the House Commerce and Economic Committee. My name is Amy Boss. I'm the Director of State and Federal Affairs at NetChoice. We are a trade association of leading internet businesses, and our mission is to make the internet safe for free expression and free enterprise. We do share the sponsor's goal to better protect minors from harmful content. Our members have taken a number of steps in recent years to improve safety online by offering a number of new features, settings, parental tools, and protections to better empower parents and assist in monitoring their children's use of social media. I should also add that the views expressed in my testimony today do not necessarily represent the views of NetChoice members. We've been having conversations on how to best protect kids with lawmakers throughout the country in a workable and constitutionally sound way. We support legislative efforts to improve digital literacy among young people. This approach will not only reach children where they are, but will help arm them to become better digital citizens. We also support laws that fill in the gaps in existing CSAM laws to better protect children from child abuse online. Today, less than 1% of all reports of child abuse online are even investigated. We also have been advocating for the federal government to pass a comprehensive privacy law, which would encompass increased protections for minors. These are solutions that do not raise many of the constitutional concerns of age-appropriate type legislation. S-289 imposes an age assurance requirement on many popular websites available to Vermont users. By mandating different experiences by age, regulated businesses would be required to determine which of their users are children and estimate the age of their users with a reasonable level of certainty. So while the legislation does not explicitly mandate that websites enact strict age verification, given the liabilities company would face, it does place online services in a position that is likely to push them to do so. Age assurance requires children and adults to share sensitive personal information like government-issued identification, documents, face scans. All of this could fall, of course, in the wrong hands and be used for identity theft and other nefarious purposes. This, of course, is at odds with the intent of the legislation. As Judge Freeman noted in granting our preliminary injunction in California's age-appropriate design code, the law compromises privacy, writing that it is actually likely to exacerbate the problem by inducing covered businesses to require consumers, including children, to divulge additional personal information. And although SB 289 has undergone some revisions and has some distinctions from the California law, it would likely suffer the same fate. Arkansas and Ohio recently enacted legislation that would implement age verification and estimation requirements. Each law is currently facing a legal challenge due to constitutional concerns. Much like AADC-type legislation we have seen in other states, this bill places a duty of care on companies to determine what content and features on their platforms might be to the detriment of a minor. The bill requires companies to consider hypothetical risks of psychological or emotional harm to the child. These terms are vague and certainly subject to interpretation. Under the threats of fines, many platforms will likely default to taking down all content on entire subjects, including constitutionally protected material. The law also imposes requirements on websites for the use, tracking, and storage of information about their users who are under the age of 18. These requirements conflict with COPPA, a federal law that governs how websites handle minors' data.
Amy, can I interrupt? I have a question. Can you point to the specific line where you're speaking that we have specific age requirements in age verification in the bill itself? And also to compare to Arkansas and Ohio, they were ban bills, correct?
They were age verification bills in Arkansas and
And
Ohio.
they banned use rather than content. So can you just go back to the first question though, and point to the specific language in the bill that gets the age verification and collecting data to do that?
So there's differentiations between what is considered defined as a child, and in the legislation, child is defined under 18. So in order to comply, companies would need to know who in fact is under 18. And in my testimony, if companies are held liable, they will want to be reasonably certain who is a child, who is not a child.
So the way that the tech works, like, are you saying that the only way to verify that a consumer is of a certain age is to collect exact data, that there's no other way using profiling and things like that they could estimate the age of a child by all of the data points of all of the data that they're collecting over the course
Sure.
of that child's life that they
So
store?
certainly there's other ways you can estimate an age of a child.
Sure, thank you.
Okay. In conclusion, I will say there are many worthy goals of this legislation, but given the trade-offs in privacy and the First Amendment issues it raises, we do oppose this legislation. Thank you again for members of the committee for the invitation to testify today.
I've just been going through your website a little bit, and I'm seeing a lot about educating children and families on how to be safer on the internet. Is that your focus, that you think that with more education, children and families will be safer?
I don't think there should be just one focus. Like I mentioned in my testimony, we do support a federal privacy law that encompasses increased protections for minors as well. I believe a privacy law is moving its way through the Vermont legislature as well. So that's a promising movement there.
So are you not? Okay. You don't have to answer my question. Thank you.
So, can you speak to the other piece of privacy legislation that's going through the House and how that may not differ than this one?
I apologize. I haven't looked at the Vermont privacy bill specifically. We have generally supported, because the internet does not, of course, have boundaries. We've generally been pretty outspoken on the federal level on privacy law and the need for a comprehensive national standard.
So Amy, just it's just because you haven't read H-121 as it currently is, it's based directly off of a copy of Connecticut SB 3 and SB 6, as well as what's passing through Colorado. I would imagine that you're keeping up with those two. Just wondering if you could speak to those two.
I think generally we would prefer, again, a national standard, but I'm happy to take a look at the Vermont bill specifically and get back to the committee.
So have you challenged Connecticut's SB 3?
No.
Great, thanks.
I think we're all in agreement with you that it'd be nice if the federal government would take this over instead of leaving it up to us to have to deal with. And it doesn't look like there's much of a chance of that happening in the next number of years. So unfortunately, it's left up to us to deal with.
Totally understand. I worked for Congress for a few years as well, and their movement can often be slow. So certainly understand your position as lawmakers at the state level to want to act in that regard.
Definitely.
Yeah, I just have a comment. I just feel like, as Vermonters, the Vermont legislators, we are really concerned about children's data safety and and the longer we wait, the more harm they're done to small children. We feel imperative to act swiftly on this and not wait for federal legislation. Of course, we would like your support.
Yep. Hi, Amy. Question for you. Can you name with any specificity the people whom you represent, the organization or businesses?
Sure. Without failing to either name the companies in the right order or missing a company, I do suggest all of our member companies are right on the front page of our website at netchoice.org.
Do you recognize that there are deleterious negative effects that are directly impacting children, primarily young girls?
Sure. I mean, I look at social media as a tool, right? So it can affect people negatively. They can use it for good. They can use it for harm. And that's why, that's one of the reasons why we have advocated for the digital literacy program, is we want our young people to use them safely, responsibly. It doesn't always affect people the same way. And would welcome further studies on that connection there as well.
Do you recognize that some greater responsibility lies with these platforms that seek to, and this is a subjective word that I'm using, that are used to manipulate and keep kids, for lack of a better phrase, addicted to these platforms? Do you recognize that?
I do recognize that, and I think it's fair to say that with the increased demand from parents, from lawmakers, it has prompted companies to take action in that regard. The studies that, these tools are not being used are not the parents' fault. I think there's needs to be way more education, making it as easy as possible for adults, for parents to turn these features on.
Amy, have you spoken to the platforms and businesses that you represent? And have you had a frank conversation with them saying, look, there's harm being done, and what do you intend to do about it? That's the question that I would ask as anybody who represents. If there's complete and clear harm being done, have your client address it and try to minimize that harm.
Yeah, it's a message they are receiving constantly. We have had those conversations. You may recall the Senate hearing a couple months ago where the CEOs of these companies were called in. It is a message that they, you know, I hope they can hear loud and clear. And it's a conversation we should be having, on how to safely use these platforms.
One more, Amy, when you've had these conversations with the people you represent, what are they doing about it?
So,
And do
there
they
are
recognize the
yeah.
harm that's being done?
So things like time limits, shutting off the auto scrolling, things like that. It was mentioned that that companies are responding in the UK to a lot of these features and turning it off. The only caveat I would raise is that the UK doesn't have a First Amendment issue there, so the
What is
government.
UK? What is that?
Sorry. The
Oh,
so
UK, I thought you said you pay.
I apologize. The
Oh,
UK.
okay.
So a number of these companies have implemented those sorts of features. The issue is, of course, you know, what role the First Amendment plays in mandating companies to turn on those features. It's an issue courts are grappling with at the moment.
Other questions?
Chair Marcotte, it's Heather.
Hi, Heather, go ahead.
Well, I just wanted to refer back to some testimony that we heard yesterday. I believe it was yesterday, regarding the pediatrician and how her child was able to, you know, to see things that she didn't want to, even though she put in all these safeguards. So putting the onus of responsibility onto parents solely is, in my view, totally irresponsible. And we have, companies have a right or a responsibility to take action towards protecting children too. And these companies have known about this for a long time, and no action has been taken place, or very little. It continues to happen. So I have some grave concerns about that.
Yeah, hearing those stories, certainly, it's incredibly uncomfortable and incredibly frustrating. Certainly more needs to be done in that area. Again, I would just, you know, caution, the difficulty arises, of course, when the government is mandating versus something, you know, providing an government mandating as opposed to companies volunteering offering these products.
Well,
but
can I follow up?
Of course.
But Chair, can I follow up?
Yeah, go ahead, Heather, the floor is
But
yours.
thank you. There's been plenty of time for some action here. So, and when companies are really, what they're doing is reprogramming children, your hormonal levels, all of these things without controls is horrible. And so we need to protect things and our children. And if we I don't think we can say that we're overzealous at all. And I don't think if companies were proactive in this situation, government would need to do what they need to do. But we do need to take action, because everyone on this committee cares deeply about children and the future of our children. And that's all I need to say.
No,
Thank
that
you.
definitely comes across. I understood. Yes.
I just want to say, I think it's government's job to protect people from harmful products. And I think that in the history of governments, they do that. And they do that when the business itself isn't willing to make change or is making change too slowly. And I'll leave it there.
Yeah. Yeah, I'd just like to follow up on Representative Brannig's remark and point out to you that, as Edie said, you know, the government has a responsibility, number one, to protect its citizens. Back in the 60s, and car manufacturers refused to put in seatbelt until Congress stepped in. Now it's the law of the land, and it's the law in each and every state, to the best of my knowledge, that you are required to wear a seatbelt because it protects not just the individual, but the state and the government as well from damages. And I think that the role that these platforms play is analogous and tragic, really.
Yeah, the difference I see here is one, the intention again is very good. I think this goes back to the 90s when Congress passed the Communications Decency Act in the name of protecting children as well. And for, that law too was struck down. And so we just want to make sure that there's caution in that, in the effort to protect children, a bill isn't struck down because we've kind of used as our motto, an unconstitutional law protects no one. So want to make sure that it is constitutionally sound and workable.
For me, it just seems like these platforms are products, and there's product liability that the owners of these platforms have. I think we need to make sure that they're providing these platforms with the consumer in mind instead of the dollars in mind. And unfortunately, we're not seeing that right now. And so I think we'll do everything that we can under the Constitution to make sure that companies operate with the best interests of children in mind instead of the best interests of the dollar in mind. Jonathan?
And I do want to say, with regards to the free speech argument, companies aren't erecting or dismantling telephone lines because it's in a form of speech. This is a means or a medium by which speech is communicated between individuals. And so that argument, speaking for myself, doesn't really hold water in terms of social media platforms.
Anything else for Amy? Amy, thank you for joining us this afternoon.
Thank you.
Alexander?
Good afternoon. Can everyone hear me okay?
Yes, we can. Thank you for joining us.
Awesome. Thank you. Good afternoon, Chair Marcotte and members of the committee. Thank you for the opportunity to testify today. For the record, my name is Alex Baropoulos, and I am the Regional Policy Manager for the Northeast at the Computer and Communications Industry Association. I'm here to testify today in opposition to S289, and I've also submitted lengthier written comments for the committee's consideration. CCIA is an international not-for-profit trade association representing a broad cross-section of communications and technology firms. CCIA holds a firm conviction that children are entitled to a higher level of security and privacy in their online experiences. Presently, our members are actively engaged in various initiatives to integrate robust protective design features into their websites and platforms. CCIA's members have been leading the effort to implement settings and parental tools to individually tailor young users' online use to the content and services that are suited to their unique lived experiences and developmental needs. CCIA appreciates all the work that this committee has done to advance a comprehensive data privacy bill, and I would like to focus my comments today on the various ways in which S289 would create conflicts with H121. First and foremost, if passed, S289 would almost certainly result in companies needing to collect significant amounts of additional personal information about Vermont residents in order to achieve compliance. Covered businesses would need to determine a user's age and how age-specific requirements under the bill should be applied, which would necessitate the collection of sensitive information like personal identifiers and geolocation data. Counter to S289's intended goals, this would paradoxically force companies to collect a higher volume of data on children. Businesses may be forced to collect personal information they don't want to collect and consumers don't want to give, and that data collection creates extra privacy and security risks for everyone while undermining the proposed protections under H121. Further, numerous entities have analyzed several existing online age verification solutions, but found none of these options could satisfactorily meet three key standards. One, providing sufficiently reliable verification. 2, allowing for complete coverage of the population, and 3, respecting the protection of individuals' data, privacy, and security. Though the intention of keeping kids safe online is commendable, S289 is counterproductive to that initiative by requiring more data collection about all internet users, including young people, and would undermine H121. Furthermore, S289 and H121 outline conflicting responsibilities and requirements for businesses, specifically when it pertains to data protection impact assessments and duties of care. The two bills have different standards for compliance with their duty of care requirements. H121 would impose a duty of care on businesses that offer services or products to consumers whose the business actually knows or willfully disregards are under the age of 18, while S289 would establish a duty of care for any business that processes a minor's data in any capacity. Additionally, H121 require DPIAs for processing activities that present a heightened risk of harm, as well as for businesses who offer products and services to consumers whom the business actually knows or willfully disregards is under the age of 18, while S289 omits DPIAs entirely. These conflicting standards would confuse businesses and obfuscate any meaningful roadmaps to compliance. Finally, there are several terms included in S289.
Can I interrupt you with the same kind of line of questioning that we just had? So your customers include Google and Amazon, and Apple. Are you telling me there's no, and Meta, and eBay, and so you're telling me there's no other way that these tech companies that are sifting through emails, text messages, online browsing, phones, devices, have no other way other than asking for like birthday to figure out how old or in what spectrum a person falls based on the content that they're watching, the messages they're sending, all of that?
So similar to the point that was raised earlier, I think when there are legal ramifications for in processing a minor's data in a certain way or treating minors differently, I think businesses would want to have that assurance that they are adequately covering and treating all users the way that they are intended to under the law. So I think that would essentially result in the need for an age verification.
Sure. Another question. So you mentioned the data assessments. Those are no longer in the bill as it passed through Senate. And so are you looking at the most recent version of the bill as it passed through the Senate with these comments?
Yes. So I was comparing H121 to S289. So I'm aware that S289 does not have DPIAs anymore, but H21, to my knowledge, still does have DPIAs and also the differing standard of duty of care.
Sure, but we're focused on 289 in here. And actually, if we're going to go to 121, that's based off of, again, Connecticut SB3. Did you have problems with Connecticut SB3 and challenge it in Connecticut?
No, we were actually worked with Senator Maroney on both the data privacy bill and on SB3 last year. And I actually was before, I know we're not talking about H121, I brought it into the conversation, but I was, happy to provide feedback and testimony earlier a few months ago on that bill for you guys and was supportive of the framework that you guys are looking to pursue in Vermont as a framework that we've seen work in other locations, and including the language that was from SB3 in Connecticut.
Thanks.
Thank you for joining us today. You mentioned in the first part of your testimony today that if the people that you represent are collecting data about children under H121, what that, to the best of my recollection and knowledge, requires is for you to protect that information about people. So by verifying a child's age or a person's age, you would still be required to protect that information, right?
So just so I'm clear, the question is if under H121 or S289?
121 for now, for this point in my argument. Okay. You're required. So would that requirement end with the passage of S289? Wouldn't you still have to protect the information about children and other people?
Yes, but
so how would that have a negative impact on the people that you represent? If it will be codified into law that they have to protect that information regardless.
Absolutely.
So the point that you made, in my opinion, is specious.
So I think the difference between the two bills is the duty of care responsibility. So in H121, the bill specifically says that the consumer, the controller actually knows or willfully disregards is a minor, versus S289, it just says minor. So it leaves some ambiguity as to the knowledge standard that is placed on businesses before determining how a user must be treated under the two proposals.
And what would you do to correct that in favor of children? What would you do? How would you change this?
So I think the protections that have been outlined under H121, the specific responsibilities, the duties that are responsible to controllers for the additional protection and treatment of minors, for their data, the way that they can opt out of targeted advertising, things of that nature. I think that is a route that we have seen to be successful in places like Connecticut, where they saw the examples of other age-appropriate design codes that were being pursued in other states and the challenges that they were facing, and decided to go to the route that they chose with SB3 last year to implement additional protections for minors while not having the challenge of a constitutional case, perhaps striking down the law. As the earlier Ms. Boss from Metros mentioned, there are no current challenges that I'm aware of to Connecticut's SB3 model, while there are numerous challenges to AADC related laws and age verification legislation.
If he has more to finish, I can ask my question.
You have more to your testimony?
No, I was just going to mention that there are a few conflicting definitions between the two bills, but that's included in my written testimony. So I'm happy to answer any additional questions.
Edie?
So I just have two questions. Are you testifying in the Senate in Vermont for H121 in support of H121?
So we have not provided testimony yet to the Senate on House Bill 121, but we are supportive of the bill broadly in the framework that that you guys have been pursuing. And I was happy to provide testimony, I think it was in February, to you all sharing our support of the bill. I think obviously we have some portions of it that we would like to see improved, but I think generally the framework is one that CCI as an organization is supportive of in the data privacy world.
And then I think that early in your testimony, one of your first lines was something about the companies that are members of your organization are working to make the internet safer for children. And so I'm curious, and if I misheard that would be, is that accurate? Is that what you said?
Yes, that was.
So I'm curious, after the accusations that against Meta and harming girls and kids, I'm curious what Meta is doing differently now to protect, those users.
Sure. So, as an organization, we don't speak on behalf of any one of our members individually. I can share that we do know from conversations that we've had with many of our members that they are implementing additional features to try to protect and improve kids' online safety and their online experiences. Removing the endless scroll feature, prohibiting autoplay, things of that nature are tools that they are rolling out and constantly evaluating to understand how they can better serve, the needs and the sort of desires of younger users and protecting them in online spaces.
But no content moderation.
So,
that you're aware
sorry,
of. Content moderation?
Content moderation? Yeah, so I think every social media platform has their own content moderation policies. So, as an organization, I don't think we're the ones who are best suited to answer that question about individual content moderation policies, but I think more broadly, I'm happy to talk about the features that they're constantly, evaluating and rolling out.
Thank you.
Good question. Alex, does your organization have specific standards that you expect your members to live by?
That's a good question. I think, we have internal principles that we focus on as an organization. What we look for example, in the data privacy legislation, what we look for when it comes to content moderation legislation, things of that nature. But I don't think it's standards that our specific members must uphold in order to, work with us as an organization. I think we sort of have set more broadly what our principles are, and if folks are in alignment with that, I think that sort of speaks to our members and their various preferences.
Okay. Any other questions? Alex, thank you very much for joining us this afternoon.
Thank you very much. Appreciate the time.
Hope,
Can you
good
hear me?
afternoon.
Good afternoon. Can you hear me okay?
Yes.
Okay, perfect. Thank you, Chair and members of the committee. Good afternoon. My name is Hope Ledford, and I'm here today on behalf of Chamber of Progress. We are a center-left tech industry group promoting technology's progressive future and working to ensure that all Americans benefit from technological leaps. Our corporate partners include companies like Amazon, Meta, Snap, and Apple, but our partners do not have a vote or veto over our positions. As someone born in the same year that the iPod came out, I can say that social media has drastically improved my life as a young person, part of a marginalized community, and I'm worried about the implications of age-appropriate design code as it may end up doing more harm than good by exacerbating the isolation of our most vulnerable young people. We appreciate the removal of a hard age verification requirement in this version. However, we remain concerned that the threat of enforcement may function as a de facto age verification requirement and chill expression online. S289 would require that a covered platform owes a minimum duty of care to the minor consumer users, including the prohibition of excessive or compulsive use of an online service, product, or feature, without providing clear guidance about what that entails. We agree promoting online safety for young people is important, but in practice, this requirement would make each site the arbiter of appropriate content for children of all age ranges and circumstances. Platforms would face difficult choices about what types of content to consider and would end up over-moderating in fear of litigation, degrading the online experience for all users, and restricting constitutionally protected speech. Algorithms play a key role in keeping online experiences safe, including for young people. They're essential for platforms to enforce their rules against content that promotes self-harm, eating disorders, and suicide. Without algorithms, all users are likely to be exposed to more types of these content. In addition, algorithms enable important interventions for youth who may be in trouble. Platforms use algorithms to direct users searching for information on eating disorders, illegal drugs, self-harm, and suicide to third-party content that can provide help, whether that be hotlines, support communities, or educational materials. And speaking from personal experience, these tools are lifelines. Platforms have long understood the concerns raised by many stakeholders, from parents to schools to government entities, that children require protection online. While state and federal policymakers have explored legislation to address this issue with mixed results, many platforms are already prioritizing child safety and are putting into place tools and procedures aimed at child safety on their platforms. S289 stands in direct contradiction to established legal precedent. The First Amendment restricts governmental interference with both the editorial discretion of private entities and the rights of individuals, regardless of age, to access lawful expression. This bill, through its content-based and speaker-based restriction, unequivocally infringes upon these fundamental freedoms. Moreover, similar legislative efforts aimed at restricting minors' access to protected speech have been met with significant judicial skepticism. Recent rulings from courts in Arkansas, California, Ohio, that regulatory measures affecting the core editorial and curatorial functions of social media companies are subject to rigorous constitutional scrutiny under the First Amendment, even if intended to safeguard young users. We agree with the need to build greater protections for younger users, but some of this bill's requirements would undermine the protection that it tries to create and would end up harming vulnerable users. It is for these reasons that we request you oppose SB 289. Thank you so much for your time.
Thank you for testifying. I appreciate your thoughts. I'm just curious, does the Chamber of Progress have a model policy for this, for how to protect children online? Consumer Reports put one together for data privacy because it was so important for them to ensure the privacy of data. And I'm curious if you have a model policy.
We do not. I do not know that if we have one or not. I'm pretty certain we do not, but we do support creating on safe spaces for young people online, so long as they do not violate the First Amendment or place greater risk for vulnerable communities through these AADC requirements.
Yeah, could you just go over the specific areas of the bill you have issues with, and then also just go through the actual what you just highlighted as the areas of concern?
Yes, for sure. So, although the removal of the hard age verification requirement, it was taken out in this version, platforms will still have to estimate age, and that will then result into a, like I mentioned, a de facto age verification requirement, which will lead to, as previous people have said, privacy concerns. We're concerned that, for instance, if
Yeah, I have a question on that. So, I mean, when you started your testimony, you were pointing to how useful algorithms can be to find out people's mental states, what they're eating or not eating, who they're talking to. So, couldn't you use those same algorithms to safely kind of choose spectrums of which children are most likely the ones viewing content?
For platforms that will be fearful of litigation, they will tend to over moderate and be and so that will lead them to want to cover more. So they will most likely use age verification in that sense.
So your members wouldn't include any of the major tech companies that have that people are on yeah, I guess I'd be curious to know if you're not, like you said, like you're representing big tech, right? So like they're already by default collecting all of this information in the background. It doesn't seem like they need to go out of their way to try to find more information. They literally have all of the information that anybody is saying and interacting with. That I would love to like hear more about that.
Yeah, so one of the things that we're concerned about that is the collection of, so like I said, they will tend to over moderate, and that includes age verification. So that would then to lead to more data. And so that would be a concern because that leaves the door open for cybersecurity concerns and malicious I guess like you'd say like data breaches and that sort of thing. So collecting more data is not necessarily a better.
Sure. So your clients include Amazon, Facebook, Google, Uber, and others. And so they're not already using algorithms for age-based advertisements to target products and services and shows and all other types of content to kids? Are they not doing that in any way?
I can't speak on behalf of them, but what I can say is that if this were to be enforced, then the company would try to avoid any sort of litigation, and that would mean that they would use a more accurate source of, I guess you could say, age verification, and so they would use more stringent age verification design instead of just guessing based on algorithms.
So they're not able to currently target advertising based on profiling of potential age ranges that people fall into.
I'm not saying that's not true.
Cool, thanks.
Well, thanks for joining us. Said early within the first few sentences of your testimony that it would be difficult for these platform owners to develop strategies to protect children. Is that accurate? Did I quote you accurately or paraphrase accurately?
I don't believe so. Their platforms are already taking measures to protect children online, and so there is an acknowledgement that there is a way. However, we do not believe that this would be the most appropriate and beneficial way to do so.
What would be?
Well, for example, in 2021, Instagram announced that they would be stricter about what types of content they recommend to 13 to 18-year-olds. And I believe then they rolled out some new settings that give teens and parents more control over potentially upsetting content. And the number one reason why users and advertisers leave platforms is because they encounter unpleasant or irrelevant content. So platforms are thus incentivized to make them safer to retain users online. As far as the exact policy or solution for protecting children online, I think that it would require a thoughtful privacy regulation as well as smart online education materials.
Thank you. Hope, does the Chamber of Progress have any data on the amount of the percentage of parents that voluntarily manage or moderate their children's intake of content via social media? In terms of, you're suggesting that it be a voluntary effort on the part of parents. Do you have any data that you mentioned all of these protections that parents can utilize to moderate their children's content intake? Do you have any data that demonstrates that parents are using those tools, if at all?
Yeah, I believe we do have data. I'm not sure on the top of my head, but I'd be happy to share that in the future.
Okay, thank you.
To follow Jonathan's line of thinking, if you're suggesting that parents take a stronger role in evaluating the information that your children are getting, is that accurate? Is that an accurate paraphrase of what your companies were trying to do, or what you're?
I don't think, not directly. I think that it would require collaboration between platforms and parents and guardians by making or by putting out tools that safeguard young people online from social media platforms. Hopefully that will make things easier for parents to in terms of enforcing those tools. So thoughtful collaboration between social media platforms, which they already are doing with parents and guardians.
Okay, well, what I infer from that is if parents need to be more involved, the inference that I get from that is that some of this information that's being peddled is dangerous. Would you agree?
Um,
And therefore, my own conclusion that I would drive to that is that there's a moral imperative on the part of the people that you represent to remove whatever may be perceived as deleterious and dangerous to children. Do you agree?
yes, but I believe that the social media platforms are already doing that and working to further those safeguards and tools, such as like removing endless scrolling, time limits. I know for certain social media platforms, you can restrict certain words, those sorts of things.
Kirk?
Hi, Hope. Thank you for talking to us. You mentioned that Instagram had instituted some improvements and changes for 13 to 18-year-olds, which is great. Glad to hear that. How does Instagram identify that age group? Do they already require that they give their date of birth, or how do they know they're 13?
I'm not certain on that, but I can definitely circle back on that.
To follow Kurt's thinking on that, and I have a very limited knowledge and with great specificity. But when you are able to identify a person's interests and they fall into the category of juvenile adult interests, you have some knowledge about how to target them. You have some, that provides you with some limited knowledge of what their preferences are. Yes?
I'm not sure. Can you repeat that?
Yes, if someone who's using one of the platforms that you represent is able to recognize what young people and older people are interested in, you have a framework around which to direct advertising and interest. And so therefore, I think it's reasonable to conclude that you have some idea of the age range of the information that people are seeking.
Yeah, that's, yes, age. So in that case, I think you're referring to age estimation, which
Yes,
is
that's what
good enough to
it
help.
started out on. Yes.
Yes. Which you've referred to, but that's different from age verification. It's not as precise enough to avoid litigation that companies will then seek to avoid, and then that will lead to the overmoderation of content online. So the difference between age estimation and age verification is how stringent it is based on determining the age. And so if companies fear litigation, then they will overmoderate and have to utilize age verification methods to avoid any litigation or complication.
Thanks. So I mean, this bill, if you could point to exactly where it asks for age verification versus age estimation, that would be helpful, because as far as we have been working on the bill, it is based on estimation, which you're saying is easy and able for a company to do. So, I mean, that's great. I think this should work for you.
Again, to that point, so companies will seek to avoid litigation at all costs. And so in that sense, they will go above and use excessive means, which means that they would then turn to age verification. So yes, we appreciate the removal of the age verification requirement in this bill, but we do believe that the enforcement of that's in the bill would then result in de facto age verification.
So in a multi-billion-dollar industry, you're saying that companies would rather not take would not rely as much as they can on age estimation, and would just flat out remove the services of which they are making billions of dollars of profit per year, by just trying to not deal with that area of which they're skeptical?
I believe that they would just would prefer not to they would
That's
just prefer
clear.
not
Yeah,
to,
get that.
They want to make spaces spaces online more safe for young people. So they would then lead them to overmoderate. For example, so if a lot of young people struggle with substance abuse or self-harm, which is a very important issue that I believe is plaguing my generation. However, if social media companies, fearing that there could be a potential for litigation or concerns, then they would overmoderate content, and that could remove any sort of content based around substance abuse or self-harm, including beneficial resources that could help connect those that are struggling with those things to communities or resources that can end up helping them get the support that they need. So we appreciate the efforts in making online safer for children, and we agree with that, but we do believe that this bill could lead to some unintended consequences that I just spoke about.
Okay. Hope, thank you very much for joining us this afternoon. We appreciate your time.
Yes, thank you, likewise.
Chris, good afternoon.
Good afternoon. Thank you, Chair Marcotte, members of the committee. Appreciate your time. Chris Gilrain, I represent TechNet in the Northeast. We are an industry association made up of 90+ companies in the innovation ecosystem. I apologize. I was hoping that I could be with you in person there today, but some things came up last minute. So again, I appreciate the opportunity to address you remotely, though I would have preferred to be in the room with you. I will also apologize, as there will be some overlap in what I'm about to say in my testimony with what you've heard already today. But TechNet believes that children deserve a heightened level of protection in online environments, and our members offer a wide variety of age-appropriate protections that empower families to curate the online experience that fits their needs. As I testified back in February, TechNet does have some remaining concerns with the comprehensive data privacy bill as passed by this committee and the House. That said, we are largely aligned on the majority of issues there, and we do firmly believe that a comprehensive data privacy law that includes stringent protections for the data of minors, like HB 121, will be more protective of children and their online experiences than S289, which includes some provisions based on a law that is currently enjoined, some that are new and entirely untested, and some that directly conflict with provisions in H121. As you've heard, H121 imposes a duty of care on controllers that offer services that the controller knows or willfully disregards are under 18. They must use reasonable care to avoid heightened risk of harm. In contrast, SB 289 would establish an entirely different standard based on different thresholds, including applying that standard to services that the controller knew or should have known that at least 2% of the audience is under 18. This misalignment would cause consumer confusion and controller confusion as to how one should comply. Changing this knowledge standard in favor of knew or should have known will also lead controllers to collect, process, and store more sensitive personal information in order to verify users' age. In addition to creating new vectors for fraud and abuse, this conflicts with data privacy best practices like data minimization, which is a key component of all comprehensive data privacy laws, including HB 121. There are also a number of dueling provisions on consent. Again, if both bills were to pass, companies would be left in doubt as to when they're required to get opt-in consent or when they're required to turn off certain processing by default, except when such processing is necessary. This will likely lead companies to over-seeking consent to avoid missteps, which could lead to consent fatigue, which is always a concern with these types of things. Again, we hope to work with you to advance common sense, comprehensive and protective data privacy legislation. Unfortunately, we are opposed to S289 as it stands. I appreciate your time.
Thank you. Any questions? Gary?
Would you mind defining what consent fatigue is?
Oh, yes. It's you see it when you get these messages, these banner messages saying, do you accept these cookies? It's a fear that the more people see these consent messages, the more inured to them they become. They just end up clicking through to the point that when you are requesting consent for truly sensitive information, people just click through without really thinking about it.
And out of curiosity, of the clients that you represent, how many of them are platforms?
I can. Is it all right if I drop links in the chat? I can link the full list of our members.
If you can just email them to Andrew and then we'll post them.
Okay.
Thank you.
But Mr. Chair, if I remember correctly, this bill deals specifically with platforms, correct?
Just platforms.
Not just platforms.
Chris, I'm just curious if the knowledge standard was aligned with that of 121, saying that's your major issue with this bill, or would you be good with the rest of the bill?
So the default requirements are problematic for us based on the kind of constitutional issues that other people have brought up. I do think that that knowledge standard is one of the key reasons that you would see platform or controllers kind of opting for more stringent age verification versus estimation.
Can you speak more to the your specific concerns in the language with as far as the First Amendment issues are that you just raised?
Yeah, so I think again, with the knowledge standard, I think that is one of the key factors that would lead to or age verification, which is one of the kind of legal infirmities there. I do think, and then requiring those default provisions is one of the issues that has been kind of enjoined. That all that said is I do want to say TechNet is not one of the entities that is engaged in those lawsuits, and I am not remotely a constitutional scholar.
So just to follow up, so with the age estimation piece, again, your members are shared with everybody else with some interesting additions like Accenture, Deloitte, Amazon. I'm just curious, so Meta, so just curious if those companies are not already using age estimation in order to do targeted advertising to what can only be assumed as a spectrum of people meeting the ages under the definition of minor.
Yeah, so I think it's a question of risk, right? I think that, the risk of providing somebody with an ad that is not actually relevant to their interests, because you estimated that they were 16 and they're actually 45. There's not much of a risk there. It's just, oh, you sent somebody an ad that they don't care about. And therefore age estimation is, fine. The risk of being non-compliant with this law would naturally make the controllers more inclined to collect more information in order to actually verify what somebody's age is, because the risk is higher than, their usual purposes.
So Chris, going off of that, I mean, if we're talking about risks, can you, I'd love to actually talk about whether or not you see risks with content that minors are potentially, as we heard from witnesses earlier, of hearing content, watching videos on YouTube that are completely inappropriate for, say, a 4-year-old. So I would love to hear you further justify weighing the risks of doing damage and harm to a child's mental health versus making a profit and risking litigation for these tech companies.
So I think we're talking about two different things, right? So content moderation, all of these platforms are working to enhance their content moderation policies at all times, sifting through, millions and millions of posts to try and make sure that people have a positive experience online. I think that, this bill is more about kind of features rather than, what content people are exposed to.
Chris, I have a number of smart devices in my home that I use to control the lights, music, etc. In December, one of them wished me happy birthday. How does it know when my birthday is? I never told it.
Yeah, I am. I don't know that I have an answer for you on that.
That's awesome. Edie?
Hi, Chris. So I'm looking at your website. I'm sorry, I got that post-lunch slump and now I'm giggling. I'll go serious here. Your website says you champion policies that foster a climate of innovation and competition. That feels a lot like go fast and break things to me, which probably is in line, but we're talking about kids here. So how do we foster a climate of innovation and safety? And how does that dovetail or not with what you do?
Yeah, actually, Representative, if you're already there, there is a landing page called entitled "Keeping Kids Safe Online." So we reached out to our members to kind of crowdsource what they are doing in terms of creating exactly a safe environment for younger users. So again, I can include that in an email to Andrew. But since you are already on the site, I think I can point to that as kind of a place to kind of find some of the resources that we've been working on.
Is it basically teaching parents what to do? I mean,
I think it's a listing of a number of both parental controls and privacy features that various platforms are using.
so it's not asking platforms to actually make their platform safer for kids. Settings and tools to give parents to manage their children's digital well-being. So it's okay. Thank you. That answered my question. It's all written. Appreciate it.
Other questions of Chris? Chris, thank you for joining us this afternoon.
Thank you.
Thank you. Josh. Good afternoon.
Thank you. Can you all hear me okay?
Yes.
All right. Well, thank you, Chairman and members of the committee for taking the time to and for inviting me to participate in this hearing today. My name is Josh Withrow. I'm a fellow with the Technology and Innovation Policy team at the R Street Institute, which is a DC-based nonprofit, nonpartisan policy think tank. You'll see in my written testimony that a lot of the objections that I have to this bill are pretty similar to the folks who have come before me here. So I don't want to belabor that or waste your time by reiterating those or going back over them. But I have a couple of other points that I just wanted to kind of make to go more into detail. I particularly support the two objections that, one, I do believe this law will run afoul of constitutional concerns about restrictions on access to speech. And I also do believe that de facto it is likely to induce companies to engage in something more specific like age verification as opposed to estimation in order to avoid liability. So I think those two main points that have been brought up are true. And what I'd have to say about that is, one thing I note about this bill as opposed to other age-appropriate design code bills is that it has been amended to try to take away certain features that are just that are a little bit more problematic or inherently unworkable. So I appreciate that there are attempts that are being made to try to tailor this legislation in a way to make it more workable. But it's my belief that there is a core problem with the AADC sort of framework, particularly the duty of care, and that makes it sort of just inherently unworkable and likely to be seen as infringing upon the First Amendment. I think to the extent that the United Kingdom's original version of this law that sort of its counterparts have been based on as effective, it can be effective because the UK does not have the sort of speech protections that we do here. Whether that's a good or a bad thing, it's sort of just a fact. And I think a duty of care can make sense for certain kinds of content that are more sort of, or features that are more sort of universally understandable or more easily defined. If you can give a site a fiduciary duty to try to protect against minors seeing obscene content, for example, and it's easier to define sort of what that harm is and what you're protecting them from. But when you start getting into details like content that might cause physical or emotional distress, that's inherently subjective. It's inherently going to be difficult to define or for companies to understand how to comply with it. And it's almost always, it's going to end up putting them in the choice of either, trying to exclude kids from their platform altogether, or else massively over moderating their content or massively changing up their features in order to try to avoid the liability that's provided by this law. So I just that's part of why, normally I'd like to come in and say that I have suggestions for ways to make this more workable, to improve the bill, to try to find a better path on it. But I do think that the core duty of care here is just not going to be constitutionally workable. And ultimately, I do believe that for the reasons that Chris, I think, probably best explained before, that, yes, these sites do have some capacity to use the data they collect to conduct age estimation, but I do believe that the liability of that they're under here will cause them to de facto move towards something like age verification. And I think that even if that wasn't problematic, I think age verification has some certain, well, to the extent that it's mandated, has some constitutional issues. But even putting that aside, I don't think that's a policy result that we should want to move towards. And unfortunately, even though it seems like this bill has taken really great pains to try to make it clear that you all don't intend to mandate that, just as a result of what the incentives are for these companies, I think that's probably where it's where their behavior will go. And so at the risk of so not to duplicate all the other members, I'll leave it at that, and happy to take your questions.
Thank you. Questions for John? Garrett?
So especially when it comes to platforms, when I find a bit of contradiction, especially a lot of the testimony that comes today, is that the platforms already have the data on hand regarding users. If a user posts something that goes against their guidelines, it can be revoked, gotten rid of, and it's not censorship because the platform's doing it. But if the platform is being held accountable for the content that their algorithm is providing to users that they have a pretty good idea are underage, it's somehow limiting speech because it's not allowing them to see certain contents. So I'm just trying to understand where this argument's coming ahead, because I keep hearing over and over again that it's a First Amendment violation. But at the same time, when you have social media companies that automatically will get rid of a grown adult speech because they say something that goes against that company's platform, I'm trying to weigh out what's going on here. So I just would like some clarification on that, because it just seems like it's a lot of dodging regarding the issue, because you have individuals that the tech companies are collecting the data on. They know they're minors. They're gearing the information towards them because they know they're minors. They have customers that they contract with that advertise them because they know they're minors. But when it comes time to say, okay, we have to try and adjust our algorithms in order to make sure that these minors are not seeing something that is inappropriate for their age bracket, then all of a sudden now it's a huge issue. So I'm just trying to wrap my head around that, because there seems to be two sides to this discussion here, where one side it's censorship and violating people's rights, but if you are a user and you post something that goes against the company's platform or their rules of service, etc., that individual who has taken what they said online that has now gone forever or is penalized for saying it, that's going against terms of community service for them. So I'm just trying to understand this argument here, because this is not a new issue. I mean, minors have been using the internet for a long time, but with each new social media generation, the issue seems to compound further and further, because these social media companies are knowingly using dopamine mining from minors that, of course, everybody knows from things such as tobacco and alcohol, their brains are not fully developed yet. So at this point in time, you are creating an addiction to individuals whose brains are not fully developed yet. So I'm just trying to wrap my head really around this, especially in defense of these companies, as we've heard from so many lobbyists that are paid by multi-billion-dollar sponsors today, that somehow this is automatically now violating people's rights because they have to be held accountable for not allowing in content, which at this point in time, content that their algorithm is dictating one way or another is somehow magically violating speech. So I'm trying to just wrap my head around that. So if you could please explain to that how there is that separation there, I would really, really love to hear that.
Boy, there's a lot to unpack there. Like kind of like multiple questions I could go into. The first thing I'll say is I do think that you're sort of addressing several issues that are connected, but which are not the same. For example, content's being companies being able to remove or deplatform a user for not following their terms of service. That's something that they've been granted the immunity to do. It's something that they have the First Amendment right to do, but they've been granted immunity from liability under Section 230 to sort of design their own policies around how they do that, as opposed to what this this duty of care, which is saying that like there are potentially entire categories of content that might be that companies may feel obligated to take down sort of wholesale for all users, for the fear that it might accidentally end up in the hands of a minor. I mean, these companies do already try to, or most of them do to some extent, or some more successfully than others, to police some of these kinds of content that are likely to come an issue. Things involving mental health issues, or suicide prevention, or body image issues, and real problematic content that it's it's a good thing to want to guard kids from. But it's a little different when you sort of say that any time that one of these pieces of content sort of makes it through, the company could be liable for that as a violation of a law such as this, and that's going to result in behavior change on the part of the company of sort of denying however much content they think they need to in order to prevent them getting dinged on that, to sort of all users. And that's likely to include beneficial content as well as the harmful stuff we do want them to prevent.
So if I may, Mr. Chair, the main point I'm getting at is that, especially with what you just said, you just mentioned that the company is already dictating what people see. So by that information, that data that the company is collecting, they are pandering to a particular set of information that user wants. Mistaken in that? If I sit here and talk about cheese on my phone, I'm going to get an ad pop up 2 hours from now about cheese on my phone.
Well, right. The companies are doing what every company that has marketing capabilities do, which is they're trying to deliver the experience and the content that their users want so that they'll want to use the product more. That's what every marketing or every company that tries to sell products to consumers does at its most basic level. That's basically just business.
Okay, so, and I understand it's just business, but at the same time, we're also talking about, okay, you have minors that are trying to access information that they should not have, or should have limitations to being had. And we're talking about individuals that are not only, I mean, and that's why I'm trying to understand here is that we're in a situation right now. Your company is trying to provide people what they need, but at the same time, if minors are not having at least some sort of safeguard regarding this, your company is knowingly providing information to minors that minors should not have. But at the same time, per your previous discussion, the company can pretty much do whatever it wants in terms of content publication because of Article 230. So I'm just trying to understand this blatant contradiction here regarding the company already knows that there's minors using their platform, and it's pretty simple just saying, hey, can you tweak your formulas just not to have this harmful content go in the minors? And the biggest argument that I've heard from everybody today that's testified is that somehow going to create an overreaction, that services that are trying to help are somehow going to get hammered. And I'm trying to understand how algorithm that can tell that I'm within 2 feet of a McDonald's is somehow not going to be able to tell the difference between someone trying to sell drugs online and a nonprofit trying to provide substance abuse prevention. And that's pretty much the argument that I've heard here today.
So the reason why that's the case is, the type of things that algorithms are good at policing are things that are sort of not contextual. It's pretty easy to design an algorithm to police like nudity or obscenity, because that's something that that's something that you know it when you see it, sort of thing. You can design an algorithm to any instance that you see something like this, make it disappear. It is much harder to do that for types of content that are contextual, things like harassment, things that might cause mental illness problems, things that might be disturbing to users, because that's going to be subjective. A piece of content that is harmful or subjective in one case may not be in another. And so if you are going to try to sort of algorithmically eliminate the entirety of that category of speech, you're necessarily going algorithms aren't really that smart, actually. They're sort of input-output devices. It's going to see any instance where a piece of subject matter refers to this thing it's been told to look out for and take it down, whether that's a self-help guide or somebody trying to sell you drugs. And we see that in sort of ridiculous cases where, like, companies are doing a good job of trying to police things we don't want to see, like hate speech. And, you know, they tell the algorithms we don't want to see Nazi imagery, and then it takes down like a ton of articles about World War II. Except now you're looking at, you know, the algorithms doing the same thing, except taking down potentially really beneficial content that might be there to help people who are having these difficulties, that, you know, that the harmful content might also be promoting. It's just not an easy thing to do in an automated or way or at scale.
Sorry, it's not an inexpensive thing to do. It is an easy thing to do, and I just want to be very clear on
Going to
that.
the moon is difficult.
It's, I,
I
so
would- Go ahead.
I jumped in, sorry, I just couldn't let it go. I'll wait my turn.
Sorry, no, my only reply is that I would dispute the idea that it's easy. It is true that the more money you throw at it, the relatively, the more possible things can get. But when it comes to, unfortunately, algorithms yet are not at the, or fortunately, depending on your point of view, the algorithms are not yet at the point where they can determine sort of the nuance of human speech and context in all cases. And so they're very blunt instruments in that way.
You're making my point for me. You need more than just an algorithm. You actually need humans working with an algorithm, which is more expensive. Thank you.
Right, which is what these companies already use. It's just, it's not a perfect system. It can't be.
Yeah, I know bottom line's more important.
I'll just suggest, thank you, Josh, for your testimony, that I believe, my understanding of artificial intelligence is that it is entirely devoted towards context discernment. And one might contend that it is actually quite cheap and easy to employ these tools for the benefit of humanity and minors in particular, in order to differentiate between these different sets of circumstances or contexts that you're referring to. And I'm quite sure that the companies that we've heard from today are employing these tool sets in a huge manner of ways. And I do imagine that are quite capable of utilizing them to that effect. That's just my thoughts. I am not a specialist in the matter, but.
Yeah, and Josh, so we're going off the quote of algorithms just aren't that smart. But in the lawsuits with 41 different states, with the social media companies that the AGs across the country have been engaging on, the companies revealed that they have done research on minors in order to test new products and features in order to reach certain age brackets. So claiming that algorithms are not smart and can't handle that just as a, like, feels like a flat out lie, which isn't super helpful.
Algorithms are, you know, it depends on what you're trying to estimate. Can you estimate the general age range of a user based on the data that's being put in there? Depending on what you're collecting, the answer is certainly yes. Can you look at a conversation that gets flagged and determine whether or not it's harmless content or satire or something, or whether it's harassment? The answer is usually no, and that's going to lead to over moderation, which is one of our main contention here. That essentially, it's not that they can't take this content down. Of course they can. The problem is that there's essentially almost no way not to massively over moderate. These things are sophisticated, but they can only be tuned to so much understanding of actual human behavior and interaction.
I actually do have a question. Is there any regulation to protect children that you support?
Certainly with respect to particular issues like protecting kids from like child exploitation and predators, I think there's a lot that can be done. My institution, we have a bunch of sort of sub policy departments that sort of overlap on this type of stuff. So we haven't endorsed a lot of specific pieces of legislation. We did endorse trying to give law enforcement more funding to sort of protect children from that kind of exploitation, because right now it's massively under prosecuted, and you know, there's millions of cases of it that are getting reported and that are not getting. So like in specific instances of specific harms like that, like child sexual exploitation, we definitely think more can be done. In terms of, you know, regulation of content or regulation of features, we do think that's something that's more appropriately left to sort of, you know, multi-stakeholder processes, and sort of between the companies and their users, and that the focus there should be more on, as has been mentioned earlier, and I know you all are skeptical of this, but more on educating both kids and their parents as to how to navigate the digital world, as opposed to sort of dictating what what exact safety measures each and every company should take.
Thank you.
We're gonna move on. We've got two more presenters and running out of time. Josh, thank you very much. We appreciate your time and your testimony.
Thank you for having me.
Thank you. Casey, good afternoon.
Afternoon, Mr. Chair, members of the committee. Thank you for inviting me to speak today. My name is Casey Mock. I'm the Chief Policy and Public Affairs Officer at the Center for Humane Technology, a 501c3 nonprofit. I'm also a lecturing fellow in technology policy at Duke Law School. I'm the former executive director of the Vermont Economic Progress Council, spent 4 years on the public policy team at Amazon. So I'm intimately familiar with these companies' business models and how they work with organizations like those that you've heard from today. Most people know our work at the Center for Humane Technology from the award-winning Netflix documentary, The Social Dilemma, which features our co-founders and unmasks the relationship between the business model of social media companies and the harmful design choices inherent in the products that they make that are driven by those business models. I'm going to spend my remarks hoping to dive a little deeper and give you a different perspective, particularly on many of the questions that members of the committee have had today for these representatives based on that background. So the folks that you've heard from today have had made two basic claims in my view. One is that complying with the law, the age appropriate design code, is not technically feasible or it'd be too burdensome without gathering more information on kids to verify their age. And two, the law is unconstitutional. The first claim is demonstrably false in my perspective. And on the second claim, they've not told you the whole story. And just to be clear, because I skipped over this, I and the organization are enthusiastically in support of this legislation and urge you to move it forward. So the ability to use even passively collected data to ascertain intimate characteristics of a customer has long been within the capabilities of the largest American companies. Many of you may have heard the story from more than a decade ago that was covered in the New York Times about a father, I believe from Minnesota, who was alarmed to receive in the mail coupons from Target that was addressed to his preteen daughter for diapers and other maternity products. After this man confronted Target about the inappropriateness of this mailing, he learned that his daughter was indeed pregnant and that Target knew about it before anyone else did because of the simple fact that she had purchased certain products such as unscented lotion, purchases which Target knew based on its research correlated highly with the preferences of expecting mothers in the first trimester of pregnancy. So if Target can tell whether you're pregnant just by the purchase of a product entirely unrelated to pregnancy, then these companies, which build themselves as the most innovative in the history of the world and brag about their moonshot factories and how their latest artificial intelligence technologies will solve climate change or cure cancer, surely these innovators can innovate in children's interests to find a way to comply with the relatively flexible, reasonably likely standard in this bill to make sure that kids are safe online. And indeed, they do have this ability. Whistleblower disclosures have revealed that based on the data Facebook, for example, already collects and research that they do on that data, they can ascertain with a high degree of certainty the age of a user. OpenAI CEO Sam Altman testified before the US Senate last year that the company is aware that a large number of its users of ChatGPT are minors, and this is a technology product that doesn't even have user profiles like social media products do. On the constitutionality question, these industry representatives have not given you the full story about their challenges, the implications of which are troubling. Despite the fact that their testimony today speaks of protecting adults and children's speech online, the crux of the company's arguments in court about the constitutionality of the age-appropriate design code comes down to two basic claims. One is that consumer data is speech, the company's speech, and that companies thus have a First Amendment right to collect data on children with little to no restriction. The second claim is that code is speech, and that companies have a First Amendment right to code whatever they want with little to no restriction. Claiming that data and code are speech, claiming that TikTok, Instagram, or YouTube have a First Amendment right to track whether your grandchild is watching sports highlights or music videos, to your individual rights to protest tyranny and oppression, should at least raise a skeptical eyebrow. Columbia law professor Tim Wu, in a great essay in The Atlantic from last fall, which we can get members of the committee if you haven't seen this, on the constitutional question, imagine this scenario. Imagine that TikTok hired private investigators to sneak into people's homes and to collect teenagers' private diaries to turn over to advertisers. If TikTok were then sued for trespassing or invasion of privacy, could they claim that the intrusion was protected by the First Amendment in that case? No, clearly not. That would be laughable. And yet these companies have claimed in court that the First Amendment would protect such behavior in the digital world. And should that absurd claim win the day, it will not only impact this legislation, but it will also overturn precedent and render many existing data privacy protections in this country unconstitutional. Similarly, if code is speech, and tech companies thus have a First Amendment right to code whatever they want, one wonders whether any sort of legislation impacting technology could ever pass constitutional muster in the future. These organizations and the companies they represent are not speaking up to protect your or your constituents' rights to protest or worship or peaceably assemble, but are making self-serving arguments that, if successful, will definitively place them above citizens. I'm sorry, was there? No.
No, you're good.
And so I urge you not to fall for this misdirection that's been offered today, and certainly not before the court has had a chance to rule on it, as it will have their claims will have far-reaching implications beyond the scope of this bill. But I'd like to take a moment to share more about who these organizations are that you've heard from today. As I mentioned, I'm a former member of the Amazon policy team, and so I'm intimately familiar with how all of these groups work. As you may have heard, NetChoice in particular obfuscated the answer to this question in the Senate, and there's been a little bit of indirectness today. But let me share with you some things that I know. NetChoice's members include Amazon, Google, Meta, Snap, TikTok. CCIA members include Amazon, Google, Meta. TechNet's members include Amazon, Google, Meta, and Snap. Chamber of Progress's members include Amazon, Google, Meta, and Snap. And in fact, the relationship between member companies and these organizations is so close that the companies routinely staff their policy teams with former employees of these organizations. I am aware of at least 4 current Amazon policy employees, for example, who are former TechNet employees. And so the fact that the talking points you've heard today are repetitive is not a coincidence. And in fact, I would be surprised, based on my experience, if these organizations are not having regular coordinating calls both with each other and with their member organizations just on this bill. And even R Street, which is a think tank does not disclose its funders, was outed by a Vice News story in 2021 that revealed the contents of a leaked internal Amazon document in which it was proposed that R Street could, quote, shield the company by, quote, providing cover when involvement by large brands is detrimental to progress. And that's exactly what you've seen here today. You're hearing from a half a dozen organizations that represent free market values or free speech online or other abstract principles, but instead they're front groups that are carefully coordinated and funded by a small core of companies. And actually, in my experience, one of these groups here today changed its position on a piece of legislation mid-session in the past because a member company paid them more money to change their stance. These are pay-to-play organizations. Google, Meta, Amazon, Snap, and TikTok hide behind these groups because they, with good reason, fear the brand damage that results from them opposing reasonable protections for kids online and having nothing to offer as an alternative. If I were in your chair, I would be deeply frustrated by the alternative suggestions you've heard today of educating users, updating child abuse laws for artificial intelligence, and providing law enforcement resources for child abusers. These are all needed, but none of which do anything to do things like stop the sales of drugs like fentanyl to minors through Snapchat, the harassment teens receive on a weekly basis on Instagram, or policing content promoting self-harm and anorexia on YouTube. The late Charlie Munger, Warren Buffett's left-hand man, once said, "Show me the incentive and I'll show you the outcome." A Harvard study released in December showed that the top 6 social media companies made $11 billion from kids under 18 in 2022 alone. $2 billion of that was from kids under the age of 12. With revenue like that, these companies are trapped. Their business model and focus on maximizing shareholder value at all costs means that product safety is a cost center, not a savings center or a profit center for the business. It costs them money and it narrows their margins. We at CHT routinely hear from internal employees on trust and safety teams at these companies that good faith initiatives to protect kids are overruled from above. And whistleblower disclosures like those from Arturo Bejar and Frances Haugen, as well as documents produced during litigation, confirm this. Just to provide one example, an internal Meta email that was disclosed in one of the state attorney general lawsuits against the company said, and I quote, "The lifetime value of a 13-year-old teen is roughly $270 per teen. This number is core to making decisions about the business, and you do not want to spend more than the lifetime value of the user." So let that sink in, $270. Meta, and we can only assume these other social media companies, believe that your children, Vermont's children, are worth only $270, and they will not spend more than that to protect them online, while they profit by the billions from them. These companies could make different decisions and profit in a way that does not exploit kids online, but their business model won't permit it until they are made to do so. Vermont companies like Front Porch Forum and Faraday, just to name two, have built successful businesses the right way, the Vermont way, by not exploiting kids' data. And Robbie Adler, a parent and Vermont tech entrepreneur himself, whom I'm sure many of you have met, has actually submitted testimony in support today. And I just wanted to draw the committee's attention to that. So instead, these companies govern themselves by Mark Zuckerberg's now famous motto, which was cited earlier, move fast and break things. That may have helped Meta become one of the richest companies in the history of the planet, but I don't know any parents who would allow a babysitter into their homes with move fast and break things as their childcare strategy. And yet with the number of hours a day your children spend on these apps, that's exactly what Vermont parents currently have, is a babysitter who believes that move fast and break things is the right way to spend time with a child. So what this bill will do in a way that is light touch, platform neutral, future-proof, and content neutral without requiring any additional data collection on children is change the incentive so that kids' safety is no longer just a business decision. It's as simple as that. And with that, I'm happy to take any questions that you all have.
Any questions for Casey? Derek?
Casey, I just want to say I appreciate you bringing up the contradictions regarding the First Amendment argument. The individual that was speaking previously, that's why I pointed out the contradiction between a platform deleting users' content because it goes against their policy, but at the same time somehow changing the content for an underage user to make sure that they're not being exposed to harmful material is somehow a big reach now. So I appreciate you bringing that up.
Thank you.
Heather?
Hi. So I really appreciate your testimony. I know we all know it's Friday afternoon. And after your testimony, I'm much happier to go into the weekend. But these big companies, I do have to say, they can protect our children. They haven't protected our children, and they aren't going to. And so it's time for us to move. So thank you. That's all.
Thank you. Just an observation. The phrase that's going to be ringing through my ears this weekend and probably for longer is the phrase over moderating. And I think they're hiding behind, these companies are hiding behind the skirt of over moderating to really make more money, to increase the bottom line for these companies. So whenever I hear over moderating, I think that's going to sum it up pretty quickly and clearly.
If I may, Mr. Chair,
sure.
I'm reminded by a tactic that I would use when I was younger, and I hated cutting the grass because I had bad grass allergies and pollen allergies, and I tried to do a bad job so that my dad wouldn't ask me to do it again. And in effect, like that's sort of what I hear with the over moderated comment, is like them threatening to do a really bad job on purpose when we know that they have the technical capability to do a fine job, and in particular with advances in things like artificial intelligence.
My two boys used to do that.
Thank you, Casey. I was just wondering, for this committee in particular, having worked so much on data privacy, I was just wondering if you could go into a little bit of just depth as far as like the interplay and having like a privacy base and then kind of the age appropriate design pieces and artificial intelligence, and how like in 2024, how critical it is to have kind of a fundamental focus on preserving people's data, as every data point is money to companies, and how all of these policies can potentially play off of each other.
Thank you for the question, Representative Priestley. Mr. Chair, I think this is an area in which a yes and approach is incredibly appropriate, because number one, on the one hand, we have a need to establish almost like rights vested in the individual, right? That your privacy will be respected and your data will be protected in a certain way. Now, at the same time, that won't completely solve the problem if the incentives driving the way in which these technologies are built and deployed don't change. And so the data privacy bill that you are working on does the former. This bill will do the latter, in part by introducing a new stakeholder into the process too, right? Like if you're building and marketing products to children, children are uniquely vulnerable, as you've heard from prior testimony. And so there should be a higher standard of care for companies that are purposefully profiting from those users. And, with AI, we have an opportunity now to learn the lessons of the last 10, 15 years of being too late to the game and trying to correct those incentives. And so I think it's high time to address those for this new technology before it becomes so entangled with our economy, with our politics, with our society, when it's harder by the day with tech company opposition to get anything meaningful passed. So I'm in favor of a yes and approach with all three of those.
Casey, thank you for joining us this afternoon. We appreciate your time.
Great to see everyone. Thank you for the time as well. Have a great weekend.
You too. Laura? Good afternoon.
Hi, good afternoon. Do we still have a hard stop at 3? Because that would give me 3 minutes.
Well, it's close. We're getting close to the end of the day, but we're willing to listen.
I'll be brief to summarize, and thank you very much for having me to talk. I'm sorry I couldn't be there in person. I was there this morning, but I had to come back down to where I am now. I'm sitting in the Queechee Library because I need to get my kids from school. I have 4 children. I'm a full-time mom, and my kids are 14, 12, 10, and 8. And I really have to think about that because it changes all the time, and I'm sleep deprived. So what I want to talk about today is I am fully in support of S289, and I am going to preface that I have 2 hats. Obviously, I'm a mom in the throes. I have 3 boys, 1 daughter, and there's absolute chaos at my house all the time, joyful chaos. But then the other hat is that I'm a public health nurse. My bachelor's of nursing is from the University of Pennsylvania, and my master's of international affairs is from Columbia University School of International and Public Affairs, where I did actually delve into studying economics and this concept of corporate behavior. And really what Mr. Mock was just describing, I want to say from a public health perspective, as he was just discussing the industry playbook. So in public health, the language now, and you'll find it in the Lancet and the British medical journals and in other peer-reviewed journals, we are actually talking about what Mr. Mock was describing in this category of health-harming products. So social media now, the Lancet just published this last year, as did another peer-reviewed journal. Social media is now classified as a commercial determinant of health. That means that puts them in the ranks with big tobacco, big sugar, weapons industry, big chemicals. And I'm going to just give one little quote, and then I'm going to talk to you about the parent side, because I just want to give you the landscape that this is now public health taking this as a serious issue. The graph behind me is the Dr. Twenge graph that shows our child suicide and self-harm rates increased exactly at the time in 2010, 11, 12, when these products became more accessible to children. And I can provide this graph to you in the research accompanying it electronically if you like. But this is an article from the British Medical Journal. I believe it was published in last year. Dr. Mani was the lead author of this article. There's now extensive evidence that large commercial actors actively shape how health issues are framed. They do so to further commercial interests, shield themselves from potential liability, and protect brand reputation. The scale and nature of these efforts contribute to a pollution of our discourse, including how we approach problems and solutions that is really rarely acknowledged. So I sent you that article, so you have it electronically. This is a public health issue. And I'm grateful, finally, that our New York City Health Commissioner has finally, at least one has issued a warning, a public health safety warning. He's calling these environmental health hazards. But I'm going to go back to now talking about this with my parent hat on. So because I am a nurse and I read all the research, this is where I am as a parent. I'm scared to death. I'm absolutely scared to death. I work with parents who have lost their children, and I entirely know the harms that happen. I've listened to parents, you know, in our advocacy groups, and you can read the stories on the internet. You can listen to parents whose children have now died, who actually say, this is what should scare us all. My child went to bed healthy. This is what's profound. The data tells us, and so do the lived experiences, that these problems on social media are now an independent risk factor for child suicidality, even when we control for all of the other factors that could be contributing. And I have a Journal of the American Medical Association that will support that when I say this is now an independent risk factor for child suicidality. So it's absolutely appropriate, given how frightening these products are. As a parent, I should be able to go and buy a toy for my child and know that it's safe. I should be able to know that it's been vetted and created to be safe before I purchase it. That's not my job, and I absolutely could never have the bandwidth, nor can any of us parents, to put on all of these controls, et cetera, that these companies are trying to pitch as the solution. It's absolutely not feasible to do. And on top of that, what we do know is that every parental control for the parents that are able to put them on, kids are going to be able to find the workarounds. Kids are really smart, and that's like a puzzle for them. And that's their job, is to be smart and to be curious. So we absolutely cannot expect parental controls to do any of the job for us on this front. I'll leave with that. If you have any questions, I'm happy to take it. And I hope that you do pass this and support it, and that we move it forward. And that we move it forward knowing that the people that created this bill are people that we can trust. They're really smart, they're experts, and this is one solution in a public health problem. This is an epidemic. There are many different levers, as we talked about. There are many different policy tools we need to put in place, and this is absolutely one of them. Thank you.
Thank you.
Okay.
All about product liability. Questions for Laura?
Just appreciate you hanging with us today.
Very compelling.
Thank you very much for joining us this afternoon. We certainly appreciate your testimony, and good luck with your 4 children.
Thank you.
We got a glimpse of one of them.
Okay. I think that's it for today. Next week, Tuesday, we'll do S30. So we'll deal with that starting at 9. We'll hear from Tricia Preston, Secretary Tebbets. And then we'll do a new walkthrough in the afternoon and see if we can finish marking that up and voting it out. Wednesday, we'll take up 59. So we'll see the new amendment from Maria. We'll hear from Deputy Commissioner of Banking. Then we'll hear from Chris Curtis from the AG's office as well on that. And we'll mark that up and vote. And if it's news to you, Chris, then we're hoping you'll be able to join us. Then after that, we'll take up S150 again. We'll hear more from people that we talked to today and taking more questions. And then I think in the afternoon after the floor, we'll have committee discussion on that one to figure out what we want to do with that, if we want to continue on with it or change policy. Thursday is Tourism Day in the morning. That's with Senate Economic Development. We'll be at the pavilion in room 267. So we'll be hearing from another number of businesses and from Commissioner Pelham as well. And then in the afternoon, we'll begin more testimony on 289 and the same on Friday, 289. That'll be next week. Questions? Hey, everybody, have a good weekend. Heather, yeah, we know it's gone long this afternoon, and hope you have a good ride home.
Dear Sophie.
Yeah, well, it'll be a good ride home.
Okay.
Thank you, guys.
Thank you. Have a good weekend.
You too.